Mediation is unique as a form of dispute resolution in that the power rests back with the parties, both whether to settle and what the content of any settlement agreement will look like. This can include considerations not available to a judge, such as ongoing relationships, commercial considerations, and personal considerations. Mediation is, at its core, a balancing exercise, comparing what could be achieved through a negotiated settlement at mediation versus what could be achieved in your best case alternative. That would often be going to court, particularly in civil and commercial, or perhaps tribunal in a workplace employment matter. So, working with the mediator, that requires careful consideration of both of those alternatives, looking at the litigation risk, the legal fees, the time and the emotional impact of a prolonged period of conflict, comparing that carefully against the benefits and the negatives of what's on the table on the day of the mediation in terms of possible resolution. There's a misconception that mediation necessitates compromise. I'm working with parties to see whether or not, when taking into account all of these considerations, there is a preferable option on the table today as a mediated settlement than what can be achieved in the best case alternative. I'm uncomfortable with the terminology of winning and losing in mediation, insofar as a win is presumed to mean a loss for the other side. But in this circumstance, if there is a preferable option, that is a win for this party. And because mediation requires agreement by both sides, if there is a settlement which is preferable for both sides of the dispute, then rather than that being a compromise, that is really a win-win.